and the leader of the opposition is not the same thing to appoint a judge of the Supreme Court. I am therefore of the view that we must seriously consider in all its ramifications that an attempt to emasculate or to cause contrition to constitutional guarantees must never be tolerated. I am of the view that wiser counsel will prevail and governments will see that notwithstanding temptations, notwithstanding provocations, it is far safer that an institution is permitted to function within its own sphere. After all, the ability to tolerate criticism, including carping criticism in judgments, is a sign of democracy. Where an organ of the state is unable to tolerate interrogation through the adjudicator, it means that it is losing its democratic ability to withstand criticism. Similarly, the judiciary too must be able to withstand criticism and must be open to constructive suggestions for the purpose of betterment of a just society. Having said this, I wish only to bring to your notice that the two provisions which enable tribunalization are to be found in Article 323A and 323B of the Constitution, which again were provisions introduced during the emergency. I am also of the view that the judgment of the Supreme Court in Gandhi's case is erroneous. In my view, the various legislative entries which have been relied upon by the Supreme Court have absolutely nothing to do with tribunals or the creation of tribunals. Entries 77, 78 and 79 of List 1 have nothing to do with the creation of tribunals. Similarly, entries 43 and 44 and also entry 95. And also entry 11A, entry 46 of List 3, with great respect, do not empower Parliament to establish tribunals. In my humble submission, the judgment in Gandhi's case, which proceeds upon the competence of Parliament to establish tribunals, overlooks that tribunals are indeed poor substitutes for regular courts of judicature. Courts of judicature are indeed capable of administering justice. By denying them that respect, by denying them that ability, and by denying them jurisdiction, I am afraid that the independence of the judiciary is bound to be affected. In my view, the Jagannath Rao Law Commission rightly took the position that the constitution of environmental courts with experts in environmental law was indeed completely antithetical to the Constitution. I am also of the view that the constitution of such tribunals with a retired judge as a presiding member is deleterious to the independence of the judiciary. In my humble submission, judges must not accept offices after debiting the office as a judge. That is my personal view. I say it with respect. I say that governments must provide for life pension for all judges, but there must be no offer of any office of a judge, and that too in the position as a chairman of a tribunal whose decision can be quashed by a court in judicial review. It is important to bear in mind that members of the public remember judges after they demit offices by virtue of the office they held. It is therefore necessary that judges must also abstain from giving opinions, and which opinions are often produced before courts as suggestive of the correct legal position. It is inconsistent with the dignity of a judge and against the spirit of Article 124(7) that written opinions are made available to litigants. I am also of the view that the words of Justice Verma who mentioned that only those persons should be considered fit for appointment as judges of the superior judiciary who combine the attributes essential for making an able, independent, and fearless judge still hold the field. The tribunals are only capable of having a judicial presence, but that is nominal in character. It is impossible to ask members of legal profession to appear before retired civil servants, and I notice the impropriety being committed in many tribunals that such non-judicial members wear the clothes and gowns of judges of the High Court. This is preposterous. I'm afraid that my protest has only fallen on deaf ears. To watch persons who are not trained in the law don the robes of a judge and sit as a judge with a retired judge is something which must be disconcerting to members of the legal profession. I do hope that one day the bar will take up this issue more vigorously. Ultimately, lawyers appear before courts. Lawyers are meant to appear and act before courts of judicature. In some extraordinary cases, there may be tribunals, but I'm afraid the tribunals and their work can be effectively undertaken by regular courts. It is necessary to reverse this process. The more you do away with the jurisdiction of courts, please do bear in mind that the rule of law will completely be emasculated. I wish to point out that many instances and inadvertent mistakes can happen even with the best of judges. And it is necessary to bear in mind that diligence and watchfulness is very necessary. I shall give you one example. When the Tehelka tapes came into the public domain, a retired judge of the Supreme Court was appointed to inquire into the allegations contained in those tapes. The learned judge was a former Chief Justice of the Patna High Court and a very senior judge of the Madras High Court, a judge very pious, extremely dignified, very popular at the bar, and a man of measured composure. He had all the qualities of a great judge. But I wish to tell you what can happen with completely upright judges and how errors of judgment can take place. And I wish to demonstrate this. This learned judge was inquiring into the conduct of the government in relation to procurement of supplies for defense. And the question was whether the transactions which were referred to in the tapes were compliant with the proper procedures and the rules prescribed for acquisitions by the government. Justice Venkata was undertaking a very, very severe and major exercise. I had the good fortune to be the counsel for that commission. I still remember that one afternoon he told me that he was honored by the Chief Justice of India by being offered a chairmanship of a tribunal in relation to advanced rulings in tax matters. I politely counseled the judge to decline it, and I told him that since he was undertaking a public inquiry, it may be perceived that the government had done something improper. But since Justice Venkata rightly believed to some extent that it was at the invitation of the Chief Justice of India, he accepted the assignment. The report was about to be published, and as often things can happen, concerted forces at work suddenly brought into public domain that the judge had accepted a second assignment from the government, as a result of which Justice Venkata resigned and his resignation was accepted. This is a case where a judge possibly thought he was doing the right thing, but as I said, even watchful judges have to be so careful because it is very necessary to practice extreme standards of abstinence insofar as judicial functions in public eye are concerned. This is only an instance where the Chief Justice of India was again a man of great repute. The judge who was the chairman of the Commission of Inquiry was again a person of great repute. But yet it is important that standards have to be followed so carefully and diligently that having regard to the subject matter which is before a person in public inquiry, you have to take a decision which is against self-interest. I need to say that the appointments of retired judges to commissions is not something new. This has been going on right from the 50s. It is another matter that eminent judges were appointed to various commissions. But it is one thing for a judge to be appointed as a chairman of a tribunal, but it is another thing to be appointed as a chairman of a quasi-judicial tribunal. An interstate water dispute is a matter of national and public importance, which is prescribed by the Constitution to be dealt with in a certain way. That is a matter which does command the attention of the judiciary. But to consider the appointment of judges as directors in government corporations or trusts is not appropriate at all. I am of the view that even the National Commission for Labour, the wage boards and other bodies must be manned by persons who are experts in the field. But to ask a judge to lend the imprimatur of his office is not entirely correct, and in any event does not enhance the independence of the judiciary. I would therefore like to conclude that Lord Denning rightly said, it does not matter who tries the cases, but they must be judges, and they should be independent of the executive. Roscoe Pound, who spoke against tribunals, said, if such tribunals are set up, they will never have the constitutional guarantee of independence that the courts have. I also wish to add that in the concept of accountability, there are two facets. One of institutional accountability, and the other, of course, is the personal accountability. We must learn from what happens in neighboring countries. In Sri Lanka, a Chief Justice, Sri Rani Bandaranayake, was impeached and she was removed. It is unfortunate that there was no inquiry and there was no adherence to the rule of law or any principles of international law. It is also sad that even though the Court of Appeal in Sri Lanka declared the process of impeachment as invalid, which view was also shared by the Supreme Court, but yet Chief Justice Bandaranayake suffered the fate. I am therefore convinced that the Judicial Standards Accountability Bill of 2010, which contained completely unacceptable provisions, and its successor bill, which is of course in the nature of the Constitutional Amendment Bill, as well as the National Judicial Commission Bill, required to be reconsidered. But they need to be reconsidered not because I am suggesting that there is a monopolistic power which is meant to be exercised by the judiciary. I am suggesting that we must first give the judiciary a clear opportunity, a clear mandate, and we must assist it in setting right what are perceived to be the criticisms of the existing process. A judge ultimately is our only trump against the state. The judge alone guarantees our liberties. The judge alone prevents us from being discriminated. It is important that we must choose our judges but we must choose them wisely. That is the mandate which the Constitution and the Supreme Court has given unto themselves. But to fulfill that mandate, it is necessary that a very high degree of criticality, introspection, and above all, the Bangalore principles must actually be employed with as great an objectivity as possible. Ultimately, self-restraint is important, but self-restraint is not a ground on which judges should fail to act when the Constitution warrants them to act. Therefore, while it is true that policy making is within the domain of the executive, while lawmaking is within the domain of the legislature, an independent judiciary which can step in to protect rights must naturally have requisite powers and jurisdiction to issue directions which must be obeyed. We must not forget that ultimately it is the rule of law which must prevail in this country. Just as the Constitution contemplated an Controller and Auditor General, it is also contemplated most importantly, and you will find that a very large number of constitutional provisions have been devoted to the judiciary. Therefore, the constitutional goals of justice, and justice is the first expression which you see in the preamble. That word justice is a word which is connotative, which is evocative. It is ultimately the cause and motivation for India's freedom. And as Sir Ashutosh Mukherjee said in one of his judgments, it is the pillar of civilization. To achieve this goal, we have to have an independent judiciary, which is an inspiring judiciary. Lastly, I wish to tell you that inspiring judges inspire the members of the legal profession. Judges who have led by example inspire you by their humility, by their nobility, and by their sense of sacrifice. I will conclude by giving you an instance of what I think is an extraordinary way a judge lived his life, and that has made me wonder that are we all really competent to understand the trials and tribulations which a judge undergoes in his life? And I wish to